Good morning, everyone. Thank you for joining us today. If you've been here before, you know my spiel. My name is Ricky Bentley. I am the program manager with Connecticut Land Conservation Council. We are the statewide service organization for Connecticut's land trusts. CLCC supports your work through advocacy, funding, and training programs like this Anatomy of a Land Transaction series. Today marks session 6 of our 7-part series, and we're shifting our focus to one of the most essential and often complex parts of any conservation deal, the legal considerations. From due diligence through closing and post-closing responsibilities, session will walk through the full legal life cycle of a land transaction. Our speakers will look at how to manage risk every step of the way. Throughout the discussion, we'll highlight how these steps tie back to the Land Trust Alliance standards and practices. Before we dive in, just a few quick housekeeping notes. Feel free to drop any questions you have in the chat. We'll have time at the end dedicated to a question and answer. We ask that you please stay muted and keep your video off during the presentation to preserve bandwidth. And finally, today's session is being recorded. We'll share the link on our YouTube channel later this week, and I'll send it as a follow-up email with some additional resources. Now, I'm pleased to introduce our panel of presenters. Our own Amy Paterson, Executive Director of CLCC, Attorney Linda Francois, and Elisabeth Moore, Executive Director of the Connecticut Farmland Trust. Thank you all for being here. Let's get started.
Thanks, Ricky. Let's move to the next slide, please, Rebecca. And we also have Rebecca Dorsey here. Rebecca is running the slides. She has been instrumental in putting this presentation together, and Rebecca is our Sandy Breslin Conservation Fellow. So thank you, Rebecca. And thanks, Ricky, for all the work that you have done in pulling this together for us. For those of you that might not know me, again, I'm Amy Blaymore Paterson, and I have served for the past 15.5 years as CLCC's first executive director. Before I came to CLCC, I spent 2 years at the Trust for Public Land as a project manager, and before that, over 20 years as a land use lawyer. And so I've had an opportunity to work on many, many land conservation transactions, and it's nice to be able to bring that skill set to the job here at CLCC. And if you look carefully at this slide, I will say that CLCC doesn't really have a law school, but we can definitely relate to the scales of justice courtesy of my colleague, Linda Francois. So next slide, please. The first thing that I want to do, just to set the stage here today, as Ricky mentioned, we are going to be alluding to the different standards and practices throughout the presentation. And when I was practicing law, and even now, when I'm asked a question, a legal question, the first place I look for insight are the Connecticut general statutes. So similarly, when a land trust poses a question to me about a topic related to its operation and work, I check the standards and practices for guidance. The standards and practices are the legal and ethical guidelines created by the land trust community and published by the National Land Trust Alliance, which is the umbrella for the nation's 100, I think there's about 1,600 land trusts now or so. The standards are a set of 12 broad principles broken down into 59 practices and 188 practice elements, which describe the essential actions needed to fulfill the standards. For land trusts seeking accreditation, the accreditation indicator elements are marked with a circle, terra firma enrollment prerequisites are denoted with a square, and elements for both are represented with a triangle. And we have the QR code for the standards and practices. If you're not familiar with them, you should be, and you can click on that, find the link, and go to them, and you'll see pretty much what I'm talking about in terms of those different indicator elements and the other prerequisites. But even if you're not pursuing accreditation, your land trust should formally adopt and follow standards and practices as, again, best practices. They will help you govern your land trust and ensure that what you're doing is in conformance with them. The relevant sections of standards and practices have been referenced throughout this Anatomy of a Land Transaction series. If you've been attending all the other workshops, you should have been hearing those throughout the presentations or seeing links to them in the chat. For today's session, we're going to focus on specific practices in 2 of the standards. Standard 9, which is ensuring sound transactions, and that states that land trusts work diligently to see that every land and conservation easement transaction is legally, ethically, and technically sound. And that standard includes 9 practices. And then standard 10, entitled tax benefits and appraisals, that standard states that land trusts work diligently to see that every charitable gift of land or conservation easement meets federal and state tax law requirements to avoid fraudulent or abusive transactions and to uphold public confidence in land conservation. And that standard includes 3 practices. Some of the subject matter that we will cover today was also the focus of a standalone workshop or more, or 1 or more, and has been offered as part of this Anatomy Land Transaction series. We have included a QR code linking you to the recordings for those sessions. Did we lose the PowerPoint? There we go. All right, so let's move on to the next slide and start dissecting your land conservation projects through the lens of risk management. And kicking us off is Elisabeth Moore. Elisabeth, I'm sure, needs no introduction. She is the executive director of the Connecticut Farmland Trust and has facilitated farmland preservation projects for decades across the state. Elisabeth, kick us off.
Thank you. I've actually also worked in Maryland, New York, and Connecticut. So if anyone has any questions about those states, I'm happy to talk to you. Okay, project selection, probably one of the most important things when you're looking at a project because it is a forever commitment. So it needs to match what your organization does. And so if you're looking, is it an open space project? Is it a habitat protection project? Is it farmland? Is it forest land? It may actually have a mix of those, and you have to decide how does it fulfill your mission? Most of you, if you're with land trusts, have a broad mission. So a project may meet may tick off many different things in your mission. One of the things that somebody said to me early on in my career was, don't be afraid to say no. It's a lot easier to say yes because you want to make the landowner happy. You may also want to increase the amount of land that your land trust is conserved. The hardest thing is to say no, but think long and hard about whether a project meets your mission, and don't be afraid of saying no. If it's not a project that meets your mission, what other group can you refer it to? Can you refer it to another land trust? Could you refer it to a public agency? Also, when you're thinking about a property, figure out what is the best way for you to protect it. Is it for you to own it? Is it for you to hold a conservation easement? And we'll get into those next. So there are 2 ways that you can conserve a farm. Or excuse me, I'm also used to talking about farms. There are 2 different ways you can protect property. You can own it in fee simple, which would just, I refer to that as just owning land, or you can hold a conservation easement. When you probably talked about this in a prior, one of your prior workshops, I'm just going to go over it very quickly. Ownership in a piece of land is a bundle of sticks. What goes with that is the ability to gift it, to lease it, to allow public access, a variety of different things. A conservation, and it's also the ability to develop a property. With a conservation easement, it holds, the landowner is specifically selling or donating the ability to develop their property. And that's what a conservation easement is it holds those development rights. All right, next. So your first option, like I mentioned, is to own it outright. And therefore the entire, all the different rights of the interest in land are transferred to the land trust and its successors, and it is forever. And in this particular case, the landowner is completely out of the picture. They have sold all their development rights, or excuse me, they've sold all their rights. And you have to make sure that this is exactly what they want. In my family situation, my mother had to really wrap her head around the fact that she was selling the property and that she would no longer have the ability to go build a house there in the future. That's an example. But so the landowner has to have a very clear understanding of that. And you also want to own it, by the way. You have to make a decision of, do you want to maintain the property? Do you want to take on everything that requires? Next. So conservation easement, which many land trusts, interestingly, in Connecticut are not doing as much. It's where the easement holder, all the development rights are transferred to the easement holder from the landowner. It's voluntary. That's something that's extremely important to indicate to a landowner. It's legally binding forever. It's what we call perpetual, and it also runs with the land, meaning that all future landowners have to be subject to it. Now, something to think about is landowners, there are very few landowners that like public access. And so if you are looking for public access, a lot of times land trusts want that, that you're going to be looking at very likely purchasing the property and not doing it through a conservation easement. We had an exception with a property in Sharon. We received a DEP open space grant for it. This is the only, well, it's one of three, but no, it's the only one that's owned by a private owner that actually has rattlesnakes on it. And I was very, very surprised that DEP wanted public access on it, but they did. And the landowner was accepting of that, but that is quite an exception. Next. Okay, because through CLCC, this is a really big deal. For many of you, actually, none of you have lawyers on staff. You also may not have lawyers who have a deep knowledge of conservation easements. Because of CLCC, CFT, other organizations, professionals, there is a deep list, and all of these are included here, of model easements for land trusts and towns to use. What's wonderful here is that you don't have to reinvent the wheel. This is the best language that's out there. It's keeping, taking into account all of the past legal cases, updates required from the IRS. I strongly recommend using these models, and most importantly, sharing them with your legal counsel. Next. All right, board approval. Obviously, well, I guess maybe I shouldn't say obviously, but you must have board approval on any time that you are accepting a donation or if you are paying for it. And it must be well documented as to why that this is a property that meets your mission and why it is something that the land trust should hold in perpetuity. And then also it must state in the documents exactly how much you're appraising it, how much you're paying for it. And also in ours, we also document how that price was arrived at. And that should be recorded in your minutes. Okay. All right. Very important thing, an appraisal. If you're doing an easement, if you're purchasing an easement, so it's most likely going to be through a public agency, whether it's Department of Agriculture, Connecticut Department of Agriculture, Connecticut Department of Energy and Environmental Protection, USDA Natural Resources Conservation Service, you are definitely going to require an appraisal. It's definitely going to require an appraisal. If you're just buying the property outright, you may not need one. It's, you'll have to decide. And also when you're looking for an appraiser, make sure that you have an appraiser who has experience, especially in conservation easements, appraising conservation easements. If you're appraising farmland, make sure that they have experience in appraising farmland. Also, that open land, that it doesn't have any structures on it. You want to make sure also that an appraiser has experience in that, because not all of them do. You do not want, for example, an appraiser who does just houses. You want to make sure that somebody knows how to appraise land. When there is a bargain sale or an outright donation of land, that the landowner must have that appraised for IRS tax purposes. And that is something that is their requirement and that they must pay for. And you need to let them know that up front. Amy, do you want to talk about that standard in practice? I don't know.
No, I think we should keep going, and then if there are questions, I can go back to that.
Okay. An engagement letter. This is something that you need to do right up front. I don't think a lot of land trusts do it, but it's incredibly important. And it also lays out the process at the very beginning so that there won't be any misunderstandings down the line in terms of what is required, what is going to, who's going to pay for what, and that type of thing. You obviously, you're identifying the land, why it meets your mission, very specifically also that you want to say that you're not giving tax benefit, any tax advice, or legal advice. It's very easy to get tripped up into that, because the more experience you have, the more likely you are to be tempted to do this. And there's some people that I work with on this webinar, and they have seen me get stuck in this situation. You just want to make sure that you don't give tax advice. It will come back to bite you. There's also something that's called the 8283, which if somebody is taking a deduction for their federal taxes for a charitable gift, whether that's for a bargain sale or an outright donation, they have to complete something called an 8283. You don't really care about this part. The part that you care about is that they are going to come to you and they are going to present a value, and that it has to pass the smell test. This is unfortunately something that land trusts have been put in the position of. And for example, I'll give you one that it has to be an appraisal done to IRS standards. And I had landowners, lovely people, they donated an easement, and they had their realtor give them a number. Well, there's no way a realtor has any idea what an easement value is. They use that appraisal. I didn't think that the number, it didn't pass the smell test. I pointed that out to a letter to them. I, by the way, did not use the phrasing smell test. And I also mentioned to them that they needed to have a qualified appraisal to IRS standards. To be honest with you, sometimes people don't like to be told that, but you do have to note it. And Amy, remind me, do we, because I haven't been in this situation, do we have to sign one if we think it does not pass the smell test?
Why don't you pose that question to Linda?
Linda.
Gee, thanks. Under standards and practices, you're just supposed to inform them of ways it's deficient. I have had one case where we did not sign it. You shouldn't sign it if you think it amounts to fraud.
Exactly, and then and document what the issue is in writing.
And make sure you obviously keep that in your records with the in the project file. You should also be asking for a stewardship gift, because you are going to have to steward, in the case of an easement, you're going to have to steward that property in perpetuity. And in the same case of ownership, you're going to have to, you're going to be stewarding that property. You're going to be owning it forever and have many stewardship issues. Make sure that that is spelled out in the letter and that you're in agreement on what that letter is. There's also going to be expenses. There's title, survey, legal, there could be environmental. Be upfront and state in there and that who is going to be paying those expenses. And that is a letter you send to the landowner, and also that they should sign it and return it to you. And you're both, you both keep a copy for your records.
And I should say that this is the purpose of the engagement letter is to manage expectations. So if you have a problem later with signing the 8283, you can say, hey, you got this engagement letter that says that we have to approve the appraisal, that it has to be a qualified appraisal before we'll sign the 8283. And that really backs up you for later, so you don't have a problem later when these things come up.
And again, this all goes to that pre-closing risk management. The more you can do upfront to manage your risks, the better off you'll be later on, and hope that things don't rear their heads when you are not expecting them. Thank you so much, Elisabeth. I'm going to turn this now over to Linda. If we can go to the next slide. Thanks, Rebecca. Linda Francois also needs no introduction. She's one of the foremost land conservation attorneys in the state and is well known for her expertise on land conservation throughout the country. So Linda, why don't you start us off on title review?
Okay, title review is what I think of as the most difficult and most important part of a land transaction. These pieces of property have seldom been subdivided, so nobody's looked at them very closely as far as their title and what the encumbrances are. They can be really tricky, and the attorney is kind of limited in what they can discover about title. Hopefully a survey will be done and things will show up on the survey, and you will do a title search, but not everything shows up on title. Before you get your title search, you have to figure out who actually owns the property so that the title searcher can actually check the right people. Is it a corporation? Are there multiple owners? Is it a trust? What's the property address? How is it assessed? This stuff seems really basic, but I cannot tell you the number of times We have wrong owners. The property is part of another piece. The assessor has it in multiple pieces, even though it's one parcel. It can be very tricky. Next slide. So a title search is absolutely essential. I recommend a title search for every land transaction. Do it early. What happens in a title search in Connecticut is the title searcher goes back through what they call the chain of title so as each owner is a link in the chain, and they go back 40 years at least to what's called the root of title. So they go back 40 years. If there's no deed there, maybe the deed's 20 years before that, they have to go back 60 years. And then they travel up the chain to the current day, looking at all the deeds and all the land records that refer to those owners in each chain, and see what they say. The 60-year-old deed may refer to an easement. That brings it into the chain of title. The easement might be 20 years older than that 60-year-old deed, but that property would be subject to that easement. So the title search finds mortgages and liens on the property. Just because there's a mortgage doesn't mean that you can't go forward with the transaction. If you're buying the property, you, as part of the closing, you pay off that lien, or the land trust attorney makes sure that that is paid off, or they could be released. If it's a conservation easement, you can what they call subordinate a mortgage, that the entity that the bank, whatever, that holds the mortgage can say, okay, the easement will come first, will come second, so that if we ever foreclose on our mortgage, it will be subject to the easement will not go away. And that's a requirement actually of the IRS if you're doing an easement that's going to be a tax deduction. Your title search will disclose existing access rights that are on the land records, not ones that people are using that don't show up in the paperwork. It will disclose surveys and maps that are on the land records, if any kinds of restrictions in the deeds, and encumbrances outside the deeds. I recommend doing a title bring down before closing. You can ask your attorney to do that. Usually they will do it. So, you know, if you're doing a transaction with this and the state is giving you a grant for it, you do your title search up front, you don't close for another 2 years. Some things could have happened in the meantime. So it's very good to, before the closing, before you're going to the town hall to record a deed, to just what they call bring down the title. So you got your title search and you just check the land records. The attorney will check the land records, or ask the title searcher to do that to make sure nothing has appeared. I had a closing for Department of Ag where a month before the closing, $1 million mortgage went on the property and it was not disclosed. And we need to make sure those things are paid off at closing. So it's very useful to do a title bring down. And when you do that, the title search gives you a document that's either a title search or a title commitment that's in your file. Doing the title bring down, you do a piece of paper that says what you did and what you found, and that goes in the file so that you have a track history of what you did on the file. So next slide.
I just was going to say one thing about title search is that I would do it very early in the process to find out if there are any issues. There can be boundary disputes. There can also be, I mentioned the property that had rattlesnakes and still does have rattlesnakes. There was an abandoned road, and it had not been officially abandoned by the town, so that had to go back and be fixed. There was also the property was compilation of several different properties. I think there was like a land swap between landowners or something. This is back in the 20s. And so when they went into the title, they found out that it was not clear what the ownership was. The people who had made the swap were long dead, and they had to track down the heirs to those particular people. It went as far as Chicago to track down these people, and it took more than a year. And so that would have been good to know at the very beginning. And also then the abandoned road process, which has to be officially done by the town. That was something else that needed to be addressed. So doing it at the beginning, so you know what you face. And there also may be things that cannot be overcome. And one of them that Linda mentioned is the subordination. If somebody has a large outstanding debt on their property, they may not, the bank may not subordinate it. I'm not saying may not in that sense. They may decide that they do not want to subordinate their interest in the property. And so it's a no-go from the very beginning. I learned from experience with a project like that. So do the your title search at the very beginning to find out if there are humps, so you know what they are. And there, like I said, there may be things that you can't overcome.
Yeah. Some people think that they can rely on title insurance to protect them from problems. There are certain things title insurance can get you, and most land trusts will buy title insurance if they're buying property or buying an easement even. Because if there is a problem, they're going to look really stupid if they spent money on the property and they didn't get any. And they've invested money in the property, so there's a known value to what they're buying. Title insurance will give you a legal defense on certain claims. So the best part of it is it gets you a lawyer. It protects from mistakes in deeds, unpaid debts, most fraud in the chain. You know, if somebody signed a deed and they didn't own the property, or they pretended to own it and didn't own it, conflicting ownership claims, improper recording. You can even possibly get survey coverage if you have a new survey and you have the title, the surveyor certify the survey to the title company. Surveyors hate to do that, but it's possible. But title insurance will not protect you from known defects. So anything in that title search that turns up or should have turned up, it won't protect you from them. It doesn't protect you from unrecorded rights of way and other encroachments. That's why you need this survey to check for those things. It doesn't protect you from environmental hazards or unpaid taxes. So there's a lot of exceptions to title insurance. Typically, land trusts, if they're getting a donation, do not buy title insurance. If they're buying, they usually will buy title insurance. Title insurance protects you as long as you own the property from those matters. But as time goes on, it's less and less likely that any of those will pop up. And some of those things, like mistakes in deeds and things like that, are possibly fixable. Next slide.
I would add also that if you are getting a grant through Connecticut Department of Agriculture or funding from USDA Natural Resources Conservation Service, they will require title insurance.
So the next step in the process is, particularly if you're buying land, is a purchase and sale agreement. Sometimes if you're there's a donation of land, you don't have anything like a purchase and sale agreement other than your engagement agreement. The purchase and sale agreement, unlike the cartoon, which says that it's about obfuscation, it's about clarifying things and managing expectations so everyone knows what the responsibilities are. So what are you paying? Are you putting down a deposit? What are you buying? It's not always just the assessor's lot. A lot of times people are cutting out a house and selling the excess acreage. You have to define that as in a way that is understandable. If you're paying less than fair market value, it's good to put in that an acknowledgement that they're paying less than fair market value and they're going to seek a charitable contribution for the gift portion of the transaction. Most land trusts will put in a funding contingency that says that they have to get their funding from private and governmental sources in a certain amount by a certain time, or they can get out of the deal. They're not held to the deal. And potentially, if their deposits, can get deposits back. Sometimes deposits are non-refundable. We try to make them refundable in most cases. An appraisal contingency, because land trusts are not supposed to pay for property. So maybe they don't have their appraisal yet. They think they know what the property is worth, but they don't have an appraisal, and they need an appraisal for their funding. And if the appraisal comes back and says you're overpaying, you need to be able to walk away from the deal or remake it. A survey, in most cases, at least if there's governmental funding, you need a survey. So who's going to pay for it? That should be in there. Is the seller paying for it because the seller is creating a piece of property that is transferable or saleable, like they're cutting off the house from the 50 acres and you're going to buy 45 acres. Is it the responsibility of the seller to do that? Because they couldn't sell it without that, or is it the buyer? A lot of times when there's state grants, the land trust buyer will pay for the survey because it is so detail oriented toward the funding. But that's a matter of negotiation. Contracts usually have a right of entry so that you can go and do the survey and you can do your due diligence. And you can even show it to prospective funders and donors. If there's a realtor involved, it specifies that, and traditionally the seller pays that. And there's usually representations that there are no hazardous materials on the property. Elisabeth, any other thoughts? Okay, next slide. So we frequently have a question of, well, when we put in a contract, we always ask for a warranty deed. Warranty deed is where the owner warrants that they own the property, they have good title, that there's no encumbrances that we're not aware of, that aren't mentioned in the contract. The contract will have a property description and a list of encumbrances in it. So we always ask for a warranty because that way they're guaranteeing it. And incidentally, if the landowner got a warranty from the previous owner, if there's a problem and it goes back further, they can sue the previous owner on their behalf because we're suing them. A quitclaim just says they're selling us whatever is described, whether they own it or not. So what you're trying to get here is good title to what you're buying. And that's not necessarily a function of whether it's a warranty or a quitclaim. You want a good title search. That's the paramount thing here. So you want a good title search that tells you what is owned by who and what are the encumbrances on it. So I don't get too caught up with you got a landowner who, there's multiple claims on the property, different owners, or for whatever reason, they don't want to give a warranty. You have to assess the risk, what the problems are, why they want to do that, and decide whether a warranty or quitclaim is good. If the grantor is judgment proof, so if your landowner that's selling you to this is a corporation that's going out of business after this, a warranty deed, you can sue them all you want, but you're not going to get any money out of them, or they're skipping town, or they're dying, or whatever, trying to collect for some problem with the title is going to be difficult. And you can still get title insurance if there's a quitclaim. So it's a judgment call about whether a warranty or a quitclaim is where you want to go. You always ask for the warranty because it's a better thing for the land trust perspective. Elisabeth?
I would add that we have never done a quitclaim. We've only done warranty in my 21 years at CFT.
I've done a few because it's a negotiation thing. But you have to be very careful about your title if you're going to go less than a warranty. But again, a warranty doesn't get you much if they're not judgment proof. I mean, if they are judgment proof, which means you can't, I mean, you can sue them all you like, but you're not going to get any money out of them. So it doesn't save you anything. Next slide. So a survey is great. We like to have an A2 survey. Most of the funders require an A2 survey. It will give you what they call the meets and bounds description. That's the description of the property, all the different sides. The state required survey requires not only the meets and bounds, but every property owner that abuts, every corner, and things have to be pinned quite substantially. So they put in physical pins into the ground showing the boundaries, which is really great because you need to be able to walk your boundaries and know where the boundary is. If you just have a map that is lines drawn on a page, you do not know where those lines are. I walked one property that had a stone wall along the boundary, and if you just looked at the stone wall, you would think that it was zigzagging because the terrain was so topographically difficult. So you really need to know where those lines are. It's not required that you have a survey, but you really need to be able to mark your boundaries and make sure you don't have any encroachments. A survey will also show encroachments. I had one survey where there was a wire fence, the remains of a wire fence along a line. And the funder required us to go remove the remains of the wire fence so it could come off the survey because they considered it an encroachment. Let's see. If it's an easement area that's not the whole property, it can define where the easement is. And it'll show the existing buildings and improvements, which may be over the line, may be on somebody else's property, may come onto yours. So it's really important to know where your boundaries are. Next slide.
All right, Linda, thank you. We're going to turn this back over to Elisabeth, who's going to give us some uh-ohs around diligence. I just want to remind you, though, that when you see that QR code, other than on the slide with standards and practices, that QR code will lead you to the link to the video recording of a workshop through this series, the Anatomy of a Land Transaction series, that focuses on that particular issue. So before we get right to that environmental due diligence, which Elisabeth is going to cover, I just want to remind you all that we did a full workshop on that topic. So with that, Elisabeth, I'm going to turn it over to you and we can go to the next slide.
I want to say one thing about surveys, that A2 which is the Porsche it's the very best and also costs the most. And so those are required, as Linda said, for any time you have public money involved in a project. However, there's something else you can do, which is called a compilation survey, which is actually, I think it's called a compilation map. It's a Class D. And the reason where it can be very helpful is that Class D is taking the survey of the boundaries. So let's say that you have, there's a project we did in Berlin. It was surrounded by subdivided land. And so recently was a subdivision around it. And so they were surveyed lines on the east, north, west boundaries so that they could get those from the land records. And then the southern side of the boundary, the southern side of the property, the boundary was I think a state road. And so that was also surveyed. So you can get something called a compilation D. It is much less expensive. And again, compilation D map. And you're not going to be able to use that for public money, but if, it's something that you can look into for your records, that's going to cost you far less than an A2. Okay, the reason that it said, is the reason for environmental due diligence is to make sure that you don't get caught in the future where something comes up to bite you that you had no idea that was there. And it might have, it may be something you have to address. It may also be something that you, in hindsight, wouldn't have moved forward with protecting the property. So, I think your first webinar, which I heard was mind-bending in terms of all of the detail, it talked about a phase 1 environmental assessment. And a phase 1 in standards and practices is not required. You have to walk around. You can walk around the property. You can do a phase 1, but again, it's walking around the property. You're walking around the property. You're looking for potential issues. You're assessing the need if you think that there's going to be a need to do a phase 1. And not every project requires one. There was an example of something, and of course, I'm referencing all projects on farmland, which is where you may, in some case, someone might say that you're going to be more likely to see an environmental issue. However, actually, I'll think of another one on the Housatonic River, right across from the across the river is the Appalachian Trail. It's completely grown up. It looks completely bucolic. It was actually in the 50s a site where somebody manufactured something for the Navy and had contaminated the land. You would have absolutely no idea looking at this property that it was contaminated and had impacted adjacent property drinking water. And that's the reason that property is never sold, is because of that, but you would have no idea looking at it. But things that I have seen, going out on a property that may have abandoned equipment, also abandoned cars, if the engine hasn't been taken out, there could be dripping oil that's gone onto the soil. another project we had, this is very sad, that they had just let the, it was a barn, they had just let the roof go to pot, and it was, there were holes in the roof, water was coming through, there was just an empty metal drum, and it had stained the ground. And I feel very, very confident that there was no issue. But we were looking to get a loan from the conservation fund. So we had to do a phase 1. And the environmental folks saw rust on the ground, the circle, print of the barrel. And in, bless us, in the environmental review, they said potential contamination 37 times. And so that cooked us. And so if we, that would have been a good thing for us to see in advance. But again, we felt very confident that it was just rust, and we did go forward with the property and purchasing the property. Something you can also look at doing is, if you have a property where we use this example of the drum or the rusted equipment, or an abandoned oil tank or something like that, you can cut that out. So that's actually part of the property that you don't take ownership of. And then the landowner is going to retain it, but you're then not taking on that liability. You can also talk to neighbors to see if they're aware of any uses, either past or present. You can search the deep list of contaminated and potentially contaminated sites. Oh yeah, here's another one. When you do one of those searches, you can also, when you look at that, you can find out what's close by. And we were protecting a farm in a rural area, and it turns out that there was a former meth site that I guess had burned. And so there was a lot of contamination. This again is in a very rural setting. It was like a mile from the property. Who knew that, hadn't contaminated ours, but property we protected, but ultimately when you do a review, it could come up. And you can look through municipal records. And again, a phase 1 is, again, it's not required for every project. And when you're looking at a property and you see something that doesn't pass the smell test, or as my late father would say, raises the hair on your neck, that's when you look at doing a phase 1. And where it says risks here, it's you want to know in advance what potential risk you're going to be at if you take on ownership. And by the way, because I had another thing, another property that if the land trust holds an easement on land that turns out to be contaminated or is contaminated from an adjacent property, like the one I described on the Housatonic River, and somebody comes, the neighbors come after the landowner because it's contaminated, their drinking water, wwhatever. The landowner is liable, not the land trust who holds the easement. And I'm not making this up. We talked to our attorney about that. So it's an important thing to know about easements, because I've been questioned about that by different land trusts.
That's true. I agree.
Thanks, Elizabeth. And again, we have the recordings for the other sessions. You should take a look. But at the end of the day, confer with your attorney. Every property is different and every circumstance is going to be different. So confer with your attorney and work with them to determine what the due diligence, the level of due diligence you should be undertaking.
And I am not an attorney, though I pretend I am, but also this is advice that you should just get from your attorney. That's very important. We can point, we can say this is to our knowledge, but you need to confirm this with your own counsel.
Thanks, Elizabeth. All right, speaking of counsel, let's go back to Linda Francois to bring us to the closing.
I love this picture. This was a great couple, and it was a Connecticut Farmland Trust deal. But you can see that the wife is so happy. The husband is kind of like, okay, what's going on? And the lawyer's job is to explain everything. So in that case, I was actually representing the landowners, not the land trust, if I'm recalling correctly. Next slide. So just because you got title to the property doesn't mean that the taxes have been paid. So if you are donated property, there may be a tax bill coming up in a long time from when you close. If you close November 1st, there's the January taxes, July taxes, and the next grand list, the following to January and July. So don't be surprised about that. And you need to figure these things out ahead of time. I'll talk a little more about that later. But typical, ever since COVID, we actually don't have sit-down closings like that picture. They're what they call paper closings. The attorneys will agree on the documents in advance. The buyer will get draft copies, then the seller will get draft copies. Everybody agrees on those documents. The seller or grantor sends the documents to the land trust attorney in escrow, the originals, and the buyer, if it's being purchased, the land trust sends the money to the seller's attorney in escrow. And frequently documents are signed on different pages and you compile them. That's what counterparts are called. And when everybody agrees that they have what they need, that they have the right amount of money, the documents are as needed and properly executed, then you tell each other that we are closed. The attorney for the seller can disperse the money from his escrow account to the seller, and the land trust can happily go off and record the documents on the land records. Next slide. So the best thing to do, and it is usually done ahead of time, is that a settlement statement is prepared between the parties. And on that settlement, it says who the buyer or land trust is and who is selling it, what is the official closing date of the closing, what consideration, that's the purchase price, that's legalese for what you paid, was, and it talks about that property tax adjustment. If you're buying land, the property tax is adjusted between the buyer and the seller. There's an assumption that when taxes are due on January 1, that covers the next 6 months. July covers the next 6 months from then. So depending on when you close, that the seller may be due, if they prepaid taxes, they may be due some funds. If they haven't paid taxes, there may be an offset for the taxes. If they're making a charitable donation, if this is a donation of property and they've already paid the taxes in advance, you can put a statement on the settlement statement that those are a charitable donation. And you're the seller is, or grantor is not due them. Grantor is the person giving the property. Grantees, the person receiving, land trust receiving the property. The settlement statement also specifies who's paying the recording fees. If the seller, grantor, had encumbrances, like say a mortgage that needed releasing in order to have clear title to give us, he needs to release those things. So it's generally their responsibility to pay for those things that clear title in advance. So there would be a recording fee that's due from them and an offset for that. The land trust, if the land trust is putting a state easement on or something afterwards, the land trust would be paying for that. And the land trust pays for the deed by which they get title. And settlement statements can be signed. Sometimes they are, sometimes they aren't. A lot of times people forget to do these on donations, but it's really nice to have a settlement statement because inevitably someone, the accountant, whatever, will want to know what was paid, when did it close, whatever. If the tax office needs it or a funder needs it, it's always good to have a settlement statement. Next slide. There's some formalities that go with these things that the lawyer hopefully is used to. They're not all aware of, there's a statute, Connecticut General Statute, that's CJS 47.6b, which requires that deeds to a land trust the land trust must sign an acceptance on the deed. That's because there was a land trust in Eastern Connecticut that kept getting given things that they did not want, and people were recording it on the land records without their knowledge. So this makes the deed voidable if that land trust signature isn't on it. Doesn't mean it's void, but it means the land trust could void it. So we always put those on. If it's a conservation easement, of course, you've got a conservation easement deed. If you're getting title insurance, there's an affidavit that's required for title insurance that says that they don't know of any other encroachments on the property and similar things like that. I always like to get that, even if I'm not getting title insurance, just because it's good to get them to acknowledge that there aren't problems. There's a conveyance tax form. Even if you're buying property and spending money, there is not a sales tax on conservation transactions. A lot of attorneys are not aware of this, but it can save the seller a lot of money. There's an exemption, you just put the exemption number in, and there's no conveyance tax. So this is a good deal for a seller to convey to the land trust because they get out of that. There's EINs and social security numbers required on that document. There's another one that's in every closing for every purpose. There's what they call a FERPTA. I like to say I am not a terrorist document, but really it's just I'm not a foreign person, so you don't have to withhold taxes. 1099, you do have to report to the feds if you pay money for property because it's taxable. Even though there's no conveyance tax on it, it's still taxable income to the seller. If you're closing on an easement, a baseline is required both by standards and practices and just general good sense. A baseline is a document which has maps and descriptions of the property, explaining what the state of the property is now. There is no Dunkin' Donuts on it. So if one appears later, you have a document that you can point to that says, see those maps? No Dunkin' Donuts. see, your closing documents. So after everybody agrees, we're closed, you can go record the documents. The attorney or their minion will trot down to the town hall and what they call run title. So we're checking the title from the last title search, from that title bring down from the title search to make sure nothing has appeared that shouldn't be there. There's no new mortgage or deed or whatever. They still own the title, subject to what you know they owe, is on it. Then if there's any releases or things like that needed to get clear title, you record those first. And that way, when the land trust records its deed or conservation easement, it has gotten title that's clear of those things. And if there's any easements that go on later to the funder or whatever, those go on later after the land trust owns the property. And the standards and practices or accreditation require that you do a recording report, which is a good idea. It's a document that says that I checked the title on this day, nothing appeared. This is, and I recorded the deed and whatever else you recorded. One pager with a signature, and that goes in the file. So you've done your due diligence as far as the closing. Next slide. Okay, so after the closing, you're not completely done. If there's a gift portion to this transaction, the land trust should give what we call a no goods or services acknowledgement letter, also known as an F8 letter because of the IRS code section, saying that no goods or services were received in exchange for the transaction other than such and such amount of money, if any. We talked about that IRS Form 8283. Hopefully you've lined that up with your engagement letter so they know ahead of time what your rules are as far as filling out the 8283. The grantor landowner is supposed to fill out the form. His name, the address, what he's giving. The appraiser signs it, saying the value that he's put on it. After those signatures are on it, the land trust reviews it for accuracy and to make sure it's reasonably correct, knowing that these things are an art. Appraising is an art. The land trust doesn't necessarily have its own appraisal of the property. I did have one case where the appraiser put a building lot in the middle of a pond, and yeah, we wouldn't sign that. And we told them why. In that case, they got the town to sign it, and because there was a joint holder and the town didn't care. But the town couldn't lose its charitable status. The land trust can. You have to let the tax assessor know that the property is now exempt. There's a quadrennial return that all land trusts file. That's called the M3. But there's also supplemental returns. So if you get this property between the 4 years, you can file that so that the nonprofit, non-taxable status will come up. But it only comes up for the next grand list. So unless there's some special ordinances this town can adopt that help with taxes, but you should know that you can be taxed and you will be taxed until the next October 1st grand list. Grand lists are October 1st, and those taxes are not paid for another year and a half. Put the original documents in your archive. From an evidentiary standpoint, these days originals are not as important as they used to be. You can check the record keeping So next slide. Keith Ainsworth, who does environmental litigation, told me to put this stuff in here. Remember that every piece of paper is discoverable. So your minutes should say what you did. We've already discussed ways where you want to know why you did it, but you don't have to put in it arguments about different things. It's not required by Robert's rules. Next slide. Okay, so I want to say that managing risk is not about no risk. Risk is a land trust business. No other private entity is going to be crazy enough to have property for public use and wildlife. Managing risk is about identifying the risk, knowing what the risk means, minimizing the risk if it's possible, deciding if the risk is worth it because of the conservation benefits or conservation values, as we call them, of the property. Like the Spanish benediction, we're trying to make sure that let no new thing arise, so that you know what you're getting into and you're good with it. Next slide.
Okay, I cannot emphasize this enough, that this is a really big deal for the landowner. This is a really big deal for the land trust. Celebrate, and there's lots of different ways to do it. Make sure you celebrate, and that we have done this with every closing. We didn't do them during COVID. And you see down in the lower right-hand corner, we celebrated after the fact with everybody that had we had not been able to celebrate with. We had a costume, Halloween costume party for Cato Corner. And we have a tradition that we always bake pie. And we're transferring people to Chris. And so I can't tell you how much people love this. And I strongly encourage you to do something like this. Even if you don't bake the pie, do something. Do this as an in-person closing. Do not do these mail things unless you can, and there's no other way to avoid it. Celebrate in person. It is such a gift to the landowner, and also it's an opportunity for the land trust to celebrate all the work that it has done over however many months or years.
Thank you, Elisabeth, and thank you, Linda, as well. Let's go to the next slide. I think we are at we've got a couple of publications on our website. There are so many publications that really can help you dig deeper into some of the issues that you have to deal with as an attorney as a land trust. And some of them you need to refer, of course, to your attorney, but others you can provide a document like some of these or publications like these and get your conversation started with your landowners before you really start having to dig into some of the issues that you heard about today. So let's move on. And let's do some Q&A. Ricky, why don't we stop the slides?